All right. Good day, ladies and gentlemen. Now we are moving to chapter 4, where we're going to talk about court organization and structure. Once again, our book is Criminal Courts: A Contemporary Perspective, 4th edition by Hemmings, Brody, and Spawn. This is the book. Once again, let me get it for you so you better see it. All right, here. So, yes, that is the textbook for the class. Chapter 4 is the introduction. The United States has a dual court structure with two distinct court systems. We have the federal court system and the 50 state court systems, which also differ from one another in significant ways. So you essentially have one level. You have the federal level of court, and then you have the state level of court. And each state is different. It has its own sovereign, I guess, governance. Um, so now the overarching rule of law, of course, is the Constitution. So within the United States, each state can't do anything that abridges or violates constitutional rights. So the states, in whatever they do, are still held to that standard. Let's see here. Um, let's see. Okay, the courtroom work group. Courtroom work group of those who perform the tasks necessary for the court system to dispense justice. So we'll talk a little bit about the work group. So those are all those involved. So we'll get to that as well. Jurisdiction. What does jurisdiction mean? It comes from the Latin word juris, and dicere, the Latin word juris, which means law, and dicere, which means to speak. So essentially, to speak law. And it denotes the legal authority, or means the legal authority or power of a court to hear a case and render a judgment in the case. So it's the power of the court to hear a case and render a judgment in the case. A court's jurisdiction is conferred by either statute or by constitution. There are four primary types of jurisdiction. You have personal jurisdiction, subject matter jurisdiction, geographic jurisdiction, and then the hierarchical jurisdiction. So we're going to talk about each one of those. First, personal jurisdiction. It refers to the authority of a court over a person, an individual person or defendant. A court may have personal jurisdiction over a person if that person comes in contact with the court, either by being a citizen of the state or by committing an act within the state, or being alleged to have committed an act within the state. That's personal jurisdiction. So then you have subject matter jurisdiction. It refers to the authority of a court to hear a particular type of case. Some courts may hear only a specified type of case, such as a juvenile court or probate court. These courts are referred to as courts of limited jurisdiction. That means they only have jurisdiction over a specific type of case. Courts that have broad subject matter jurisdiction and may hear both civil and criminal proceedings are referred to as courts of general jurisdiction. So you have limited jurisdiction. Within subject matter jurisdiction, you have courts of limited jurisdiction, and then you also have courts of general jurisdiction. So we'll talk about those as well. Different states allocate the subject matter jurisdiction of their courts differently, based on a variety of factors, including geography and population density. So we'll talk about that. So you have different states that have different population densities, so that makes the court systems between certain states different. North Carolina is a relatively, complex court system. So each county has jurisdiction, and then within each county, you have district and superior courts. You have magistrate courts. So we'll talk about that hierarchy in a little bit. Geographic jurisdiction. This refers to the authority of a court to hear cases that arise within specified geographic boundaries, such as a city, county, state, or country. This also is referred to as venue. So when we say venue, that essentially is another word for geographic jurisdiction. So if this is the correct venue, this means this is a court that has correct geographic jurisdiction over a case. For a court to have jurisdiction over an event, the event must have taken place within the geographic jurisdiction of the court. That is to say, a person who assaults someone in Washington State could not be prosecuted in Arizona for that assault. That's just an explanation. When multiple crimes occur in more than one jurisdiction, or when one continuing offense occurs and is continued through multiple jurisdictions, that crime or crimes can be separately prosecuted in each jurisdiction in which a part of that crime occurred without violating the double jeopardy prohibition. So we talked in other chapter, in the last chapter, I believe, about the Constitution and the double jeopardy prohibition. That means you can't be tried for the same exact case twice. So this is an exception. You're not being tried for the same thing twice if it's one crime that takes place and is continued over multiple jurisdictions. Let's say someone has kidnaps a person in California, and then when they kidnap them, they put them in the trunk of the car, and they drive through Arizona, then they let's say they drive through Nevada to go to Las Vegas, and they drive through Nevada, and when they drive through Nevada, they cross over into Colorado. At this point, now you have the kidnapping, which took place in California, but you also have what could be considered kidnapping in those other two states as well, because you you essentially transport the person through those states. And in some jurisdictions, it's actually illegal to transport a person against their will across state lines. So you can get charged for that same body of crimes or that one crime that continued in multiple jurisdictions for different stuff and be tried in those jurisdictions, and is not violative of the double jeopardy clause. So, like I said, each state derives its authority from a different source, its own state constitution. Next, we have a hierarchical jurisdiction. It refers to the division of duties and roles amongst various courts within a single jurisdiction. Talk a lot about that. So, once you're in a jurisdiction, you have certain courts that are meant to hear a certain level of cases. So that means that depending on what court you're in, that court may not have jurisdiction or over a certain case because a court above it or below it has jurisdiction. Excuse me, sorry about that. When we talk about hierarchical jurisdiction, there are two different types of jurisdiction within hierarchical jurisdiction. First, you have original jurisdiction. This refers to the trial court. So anytime you hear me say original jurisdiction or trial jurisdiction, those are the same thing. That's essentially where a case begins and the trial is held. In North Carolina, criminal district court has original jurisdiction over misdemeanors, and criminal superior court has original jurisdiction over felonies. So that means in order for a misdemeanor in North Carolina to get up to superior court, it either has to be indicted with felonies, or it has to be a misdemeanor case that was tried where the defendant lost and appealed for a new trial, and that now pushes, by the defendant's own actions, that pushes the case up to superior court for a new trial, which would be a jury trial. So that's just an example of original jurisdiction and how it works. So the trial court has original jurisdiction, and then from there it goes up. Then we have appellate jurisdiction. This refers to higher courts having the authority to review the verdicts of trial courts after a losing party in the court of original jurisdiction files an appeal. So, of course, let's use North Carolina as an example. A case is tried in superior court, a felony case. It's a jury trial. The defendant loses, is convicted and sentenced. And after sentencing, they appeal. When they appeal, that appeal goes up based upon, and the court above it, which would be the North Carolina Court of Appeals, would have appellate jurisdiction over the case. So that's what that means. That means they have the right to review the rulings and the happenings and the record of a lower court. Appeals courts may affirm or reverse a lower court judgment and either enter a new judgment or send the case back down to lower court for reconsideration or what we call new trial or trial de novo, based on the appeals court determination of whatever error was made in the court below. So those are the options. They could reverse it or send it back down, affirm it, reverse it, or send it back down for a new trial. So now we move on to the structure and jurisdiction of the United States courts. This is the federal side. America has a dual court system that includes 50 separate state court systems, which differ from one another, and the federal court system. So that means in total, United States has 51 court systems. We have the one federal court system with its hierarchy, and then we have each individual state, all 50 states. So in total, there are 51 court systems within the United States. Jurisdiction of the federal court, the jurisdiction of a federal and state court may overlap because what is a crime in a state may also be punishable under federal law in some circumstances. A brief historical overview. Article 3 of the United States Constitution provides that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may, from time to time, ordain and establish. Courts created under this article are known as Article 3 courts. So, of course, the Constitution created the Supreme Court, but it gave Congress the right in Article 3 to create any other courts it needs that are under the Supreme Court of the United States. So that's Article 3 of the United States Constitution. That's what creates our judiciary, the federal judiciary. The Judiciary Act of 1789, not long after our country not only declared its freedom, but won the war and was actually a free and sovereign nation, created a federal judicial system composed of the Supreme Court, then with 6 justices, 3 circuit courts, and 13 district or trial courts. It's 13 wide. You have 13 colonies. This act stipulated that the boundaries of the federal district and circuit courts were to be drawn along state lines, which would connect each federal district court to the political culture of each state. So when they're creating the Constitution, the founding fathers, of course, there were some founding fathers that were from states with larger populaces, and there were certain there were other lawmakers that were from states that had less of a population. So that became like the compromise. We're going to create a court system. We want to create a court system where, even though it's federal, the federal courts are, and the district courts are in one state, and we want people there to be the people that are the court personnel, because we want the state even in the federal law, the way it's going to be enforced, we want it to be done by people who are essentially local and know the state. Let's see here. Okay, federal district court judges must be residents of the state in which the district court is located, which prevents out-of-state judges from serving for fear that they would not understand the local situation, which is essentially what I just said. The Court of Appeals Act of 1891, it created the Circuit Courts of Appeal, a new layer of intermediate appellate courts that would hear appeals from the district courts, and gave the Supreme Court more discretion in deciding which cases to hear. Of course, this is because of the growing population. So essentially, at the infancy stage of our sovereign nation, of course, as I said before, we had the Supreme Court. We had 3 circuit courts, or like appeals courts, and then you had the 13 district courts. And those are trial courts, federal trial courts for essentially each colony. Of course, the country was much smaller then, and much less populated. So of course, by 1891, you're essentially talking 100 years later. By that time, America had more than doubled in size. By that time, America had spread from the East Coast pretty much to the West Coast, from the Atlantic to the Pacific. So at that point in time, we had we had to expand the court system. We had to create more district courts, and also we had to create more circuit courts that could take circuit intermediate courts that could directly take appeals from those district courts, and so that's how that went. And it also created a situation where now, at that point, the Supreme Court had more discretion as to what they were going to hear because they were now appellate courts below the Supreme Court. The Supreme Court at that point could become a little bit more picky and choosy about what it wanted to hear. So that created their discretion. Let's see. Okay. The Judges Bill of 1925. It gave the district courts original jurisdiction to try cases involving federal statutes or the federal Constitution with the right to appeal to circuit courts. All right. As a result of the passage of that bill, most cases can no longer be appealed as a matter of right directly to the Supreme Court. So at that point, when you appeal, you have to appeal to a circuit appeals court. So the appeals court that has jurisdiction over your circuit, that's where the case from the district court, federal court, would be appealed. So it gets appealed to that court, and and of course, they hear the appeal. They make a decision. If it's not what you want to hear, at that point, then you have to file a writ of certiorari, which is a request for a writ of certiorari, and that's essentially a request for the Supreme Court of the United States to hear a case. But they have discretion, so they can decide whether or not to hear it. Of course, it would have to be a federal question or a constitutional question, and it would have to be pretty important for them to hear it. The U.S. magistrate judges were created in 1968. They were like a judiciary, kind of lower judicial officials that were part of like preliminary processes, and that helped spread the workload in preliminary cases to people who were quasi-judicial or what we call magistrates, as opposed to the trial court judges. So now first appearances, preliminary hearings and stuff of that nature could be done in front of magistrates, as opposed to taking everything in front of a fewer number of judges. So it increased, it spread the workload out a little bit. Then in 1984, United States Sentencing Commission was created to develop a structured sentencing guideline, which created structured sentencing, which made sentencing fair and made it predictable. Most criminal law enforcement and prosecution is handled by state and local agencies, though. Even though we have a vast federal system, the bulk of criminal law, criminal justice, and things that go on in the criminal justice system, and the bulk of the contact that the average citizen has with the criminal justice system is with state and local courts. So even before the U.S. Constitution, the colonies or the states, as sovereign entities, already had their own constitutions and court structures before we were even really a country. This is why state court structures do not necessarily mirror the federal court structure. So federal courts, you have your district courts. These are the trial courts or courts of original jurisdiction in the federal system. So that's where your trials are held in the federal court. You have 94 United States district courts spread throughout the 50 states and U.S. territories. Each state has at least one United States district court. Some have as many as 4. In North Carolina, we actually have 3. Well, I guess actually 3.5, and we'll talk about the judicial district in a minute. Okay, I'll say North Carolina has 3. We have the Western District, which is in Charlotte. We have the Middle District, which is in Greensboro and Winston. So there's the Middle District Courthouse is right around the corner from my law office. The Federal Middle District in North Carolina is right here in Greensboro, but they have like a satellite courthouse in Winston-Salem. So there are 2 within the triad. There are 2 federal district courts. So even though it's 3 judicial districts, there's another kind of annex of the Middle District in Winston-Salem. And then to the east, the Eastern District, you have Raleigh. So that's where that is. No district ever crosses state lines. So the three judicial districts we have are the 3 judicial districts we have. Each district has more than one judge, and these judges are appointed by the President of the United States, and they're appointed for lifelong, and they have to retire or die out. But only one judge presides over a particular case or trial at a time. There are 677 federal district judges, magistrate judges. They're subordinate judicial officers who have limited jurisdiction and conduct preliminary proceedings in cases before the district court and issue warrants. So they help with some of the quasi-judicial things that need to be handled. Like I said, sometimes creating bonds and stuff like that, or bail, and preliminary hearings and first appearances. They can get that stuff out of the way, so the trial judges, don't have to be burdened with all that. So, judgments entered by magistrates are considered judgments of the district court. Then we have diversity citizenship. This refers to a situation where the opposing parties are from different states. Federal courts were given diversity jurisdiction because the founding fathers were concerned that state courts presented with a suit between a state resident and a non-resident would be biased in favor of their resident. Allowing the non-resident to shift the case to federal court on the basis of diversity of citizenship was seen as a means of ensuring a fair trial, assuming that federal courts would be neutral. So that's diversity of citizenship. That's another way that you can get into federal court, even if if you're suing or you have an action against someone in another state, you can sue them depending on what the subject matter of the suit is. You can sue them or take action against them in federal court. So, and it's based upon the diversity of citizenship. So also included in the federal courts are the U.S. bankruptcy courts, U.S. International Trade Court, or U.S. Court of International Trade, and U.S. Court of Federal Claims. Federal courts and other entities outside the judicial branch. You have military courts or military tribunals, and you have courts of veteran appeals, and you have U.S. tax court, and you have the federal administrative agencies and boards. So, Court of Appeals, this is a second tier in the federal system, also referred to as the circuit courts. These courts handle decisions from the U.S. district courts in the circuit. There are 13 courts of appeals, 11 for the 50 states, 1 for D.C. by itself, and 1 for the federal circuit in general. So altogether, 13 circuit courts of appeals, federal circuit courts of appeals. The jurisdiction of the courts of appeals for the federal circuit is limited to appeals from specified federal agencies and decisions of the U.S. Court of Federal Claims and the U.S. Court of International Trade, 2 specialized federal trial courts. D.C. has its own appeals court in part because it is not a state, and in part because of the large volume of cases filed in D.C. due to the geographic jurisdiction of all the federal agencies housed in D.C. So it has its own appeals court. The 11 remaining courts of appeals are organized on a territorial basis, with each covering several states. So, for your information, North Carolina is within the 4th Circuit Appellate District, so the 4th District. Also included with North Carolina is 4 other states. It's North Carolina, South Carolina, Virginia, West Virginia, and Maryland. So those 5 states comprise of the 4th Circuit. So any cases from those states that are appealed are going to go to the 4th Circuit Court of Appeal. It goes to the 4th Circuit. So remember that we are in the 4th Circuit. You may see, you never know, you may see that again. Both criminal and civil matters can be heard by the courts of appeals, and these appellate courts also hear a large number of habeas corpus petitions from inmates. There are 179 judges assigned to the Circuit Court of Appeals. Appeals are heard by 3-judge panels selected at random so that any of the judges on a particular court of appeal may sit with one judge on one case and a different judge on the next case. After reading written arguments or briefs and listening to oral arguments, the panel of judges discusses the case and votes whether to affirm or reverse the lower court ruling. If two panels in the same circuit issue different opinions on a similar issue, the entire circuit may decide to sit what they call en banc or en banc, which means as a group. So that means that the judges, that means all the circuit appellate judges would meet as one to settle this issue of difference. They will rehear the case and issue an opinion that will be binding on the entire circuit. That's why sometimes you have different circuits where there's kind of a different ruling. So in different circuits, you're not in that circuit, so that ruling doesn't apply to you. Every once in a while, if it's a constitutional issue, the Supreme Court can kind of unify what's going to the circuits by deciding what is and what isn't constitutional, and that would apply to all federal circuits. So let me see. Okay. All right. The next level, of course, is the Supreme Court in the hierarchy. So it's the district courts at the bottom, the circuit courts or courts of appeals in the middle, and then the highest court or court of last resort on the federal side is the Supreme Court. Because it is the final step in the federal court system, and for any case involving the interpretation of a federal statute or the United States Constitution, it is sometimes referred to as the court of last resort. The Supreme Court has original trial jurisdiction over trial jurisdiction where they can actually try cases over a very small number of situations, including suits between states, suits between the United States and a state, and suits between a state and a foreign citizen. The Supreme Court assigns the trial to a special master and then hears an appeal from the special master's decision. So those are the only situations where the Supreme Court has trial jurisdiction. Other than that, it's all appeals. So the bulk of the Supreme Court docket consists almost entirely of cases taken on appeal from either the federal courts of appeals or state Supreme Courts. Because remember, they're not just the court of last resort for the federal government, for the federal side, but the Supreme Court of the United States is actually the court of last resort across the board in America. So if there's a constitutional or federal issue that's being discussed in a state court decision, the Supreme Court, it could be appealed all the way to the federal Supreme Court or the United States Supreme Court. And that happens in a lot of cases. So a lot of cases you hear in criminal justice, important cases like Terry v. Ohio, these are cases that started out in state court, and they were appealed because, of course, they were appealed to the United States Supreme Court because there was the defendant, of course, alleged that some type of constitutional right was violated, and then the Supreme Court chose to render a judgment to create the law or precedent in that situation. The Supreme Court has discretionary authority to choose which appeals it takes and which ones it refuses to hear. Over 9,000 review requests are sent yearly, with fewer than 100 cases chosen to be reviewed. So you're talking essentially a little bit more than 10% of not even 10%, 1% of cases that are actually heard. So it's not a lot. So appealing the Supreme Court probably means they're not going to hear it more than likely. They turn down almost everything. You file a petition for writ of certiorari, as I said before. That's when someone asks the Supreme Court to hear an appeal. The writ of certiorari is an order issued by the United States Supreme Court to a lower court to send the record of the case up for review. So that means when they issue that writ of certiorari, that's essentially them saying, we will hear your case, now send us the documents so we can review it. When a petition is filed, the justices review it and vote whether to grant it and to hear the appeal. 4 out of 9 justices must vote to review the case before a writ of certiorari is granted. And this is what we call the rule of four. So 4 out of 9 justices have to agree. That's less than half have to agree to hear the case. Otherwise, the petition is denied. When denied, the decision of the lower court is left undisturbed. The Supreme Court's refusal to accept the petition for writ of certiorari is not considered a decision on the merits of that whatever that case is below. All it is them saying, "Hey, we're not hearing it. It is what it is. We're not saying that what the court did, the lower court did, is even right. We're just saying we're not hearing it. So it's not based upon the merits of the case. As a matter of fact, they wouldn't even know the merits because they decided not to hear it and make a decision on the merits. So the refusal to hear a case has no precedential, or doesn't create any precedent. It doesn't have any precedential value. For whatever reason, the court has just decided not to hear the appeal. That's all it means. 3 main functions of the Supreme Court. The Supreme Court uses its discretionary docket to take only those cases that fit into one of these categories. These are cases that resolve disputes between states, cases that resolve conflicting opinions of lower federal and state courts, and cases that resolve constitutional questions. The Supreme Court of the United States also hears appeals from both courts of appeals and state Supreme Courts. Supreme Court hears appeals from state Supreme Courts only when they involve a substantial federal or constitutional question. So if it's coming from the state court and going directly to the federal Supreme Court, then it has to be some type of federal or constitutional question. It has to be pretty serious. Most disputed criminal and civil matters never come to the attention of the United States Supreme Court, leading to the contradictory decisions from state to state or from one federal circuit to another, because they don't hear most of the cases, so it kind of is what it is. It's kind of when in Rome, do as Romans do. So you're in that jurisdiction, this is what's legal and what it is, and when you're in another jurisdiction or circuit, this is what it is and what it isn't. The court is composed of 9 justices, one of whom is designated the Chief Justice, and there are 8 associate justices that serve with him. Congress has the authority to either enlarge or reduce the number of justices on the Supreme Court. The conservatism of the Supreme Court. Conservatism of the law and its emphasis on precedent and predictability helps to maintain status quo. Essentially what that means is you have a court that's primarily always been older white men. Supreme Court has historically included white Protestant males. In 1965, the first black justice, Thurgood Marshall, he retired in 1990, and he was replaced by the appointment of President George H. Bush, the first Bush, by Clarence Thomas. So he replaced Marshall after his retirement. So essentially, to keep status quo, it's almost like they said, well, a black man leaves, let's appoint another black man. So Clarence Thomas replaced Thurgood Marshall in 1991. In 1981, the first female, Sandra Day O'Connor, was appointed to the court. And she would have been appointed by Ronald Reagan. In 1993, Ruth Bader Ginsburg became the second female alongside O'Connor. She was appointed by Bill Clinton. In 2009, the first Hispanic female, Sonia Sotomayor, was appointed by President Barack Obama. And in 2010, Elena Kagan was appointed by President Barack Obama. So you have a court, you have one black male, you have a Hispanic female, you have white females, and then they also talked about the religious makeup, some Catholics, Protestants, on the Supreme Court. And I know people say, well, why does their religion matter? But you got to think religion kind of sets societal norms and what we think is right and wrong. So when they're making decisions, their religion is part of what makes them and part of what creates the rationale for their judicial decision. So you have to think about that. All right, state courts. So finally, we're out of the federal court system, and we're going to talk about state courts. The bulk of court cases, criminal and civil, are handled in state courts, with the number of cases increasing yearly. The bulk of states have a four-tiered hierarchical system. So remember that most of all the action in the court system in general in America is on the state and local level. You have some federal stuff going on, but not anywhere close to the amount of stuff that's going on the state level. As a matter of fact, if you in Greensboro, the federal courthouse is right across the street, like on West Market, from the state courthouse. And the state courthouse is popping every day. It's packed. People in there. It's hustle and bustle. And unless it's a serious case or some type of important, famous case or something like that going on in federal court, nobody barely pays attention to the federal courthouse. Now, they got cases going on over there, but the volume is nowhere close to the state courthouse. So let's talk about the first tier of, now this is not every state, but this is generally so I'll infuse what we do in North Carolina as I talk. You have the courts of limited jurisdiction. This is the first level of state courts. This is like what we call the justice of the peace court, magistrate's court, and like municipal court, where small level stuff like certain infraction level speeding tickets and certain type of minor crimes may be handled. These courts handle a variety of matters, including minor criminal offenses, traffic offenses, violations of municipal ordinances, juvenile delinquency hearings, involuntary commitments, and civil disputes under a certain dollar value. Proceedings are often more informal in nature than they are in trial or appellate courts. There's usually no right to a jury trial, and trials are presided over by a magistrate judge. Where the trial is a bench trial. And a bench trial is a trial where the judge decides the matter of law and evidence and also decides guilt or innocence. So there's no jury. It's just a judge that decides everything. So upon appeal by either party, the case is not reviewed, but is sent up to the next level for a trial de novo. As I said before, that means new trial de novo. This is because these courts are not courts of record, so it would be hard for them to appeal, and for the court right above them to review what happened when what happened wasn't recorded verbatim. Now you have the clerks keeping the judgments, so the judgments and whatever adjudications, whatever happens in court, as far as what's ordered is kept by the clerks, who are like the custodians of the record. But as far as verbatim keeping of or transcripts or what was said, that doesn't happen in these courts, in courts of limited jurisdiction or these magistrate courts. So that means when it's appealed, it's not appealed for a review, but it's appealed for a new trial. So in other words, we just want to go up the next level. We feel like we can do better and get a better result up in a new trial. 3 reasons why courts of limited jurisdiction are important. 1, for many citizens, they are the only experience that most will ever have with the court system. So you get a traffic ticket, you're probably going. It's a minor traffic ticket. Now you're not speeding on a spaceship, but you're driving 9 over or something like that, or a seatbelt violation. You're going to magistrate's court. So most people in most of our encounters are with local law enforcement, minor stuff, and that's where that goes. So that's why it's important, because that's where the bulk of cases are. The bulk, even though there's small cases, a lot of people in the courthouse for that stuff. 2, the next reason why these courts are important. There are many of these courts, and they process a tremendous number of cases. As I said before, a lot of humanity moving through these courts. These courts are often involved in important parts of the pretrial process in criminal cases, like the first appearance, arraignment, or preliminary hearing. And that's definitely how it is in Greensboro. So if you are charged with a misdemeanor or whatever, your first appearance, if you're not in custody, your very first court date is actually going to be in front of a magistrate judge, and they're going to ask you how you want to proceed. It's all about It's essentially all about how you're going to be represented. Inform you of your right, and they ask you, do you want to hire an attorney, represent yourself, or would you ask, or are you requesting court-appointed counsel? So you govern yourself for court. You make a decision, and you go, and the court governs itself accordingly based upon the decision you make, and they go from there. The third reason, these courts are often involved in important parts, and I just said that. I'm sorry. So that is the third reason. Okay. Then after courts of limited jurisdiction on the bottom, then you take it a step up to courts of general jurisdiction. Trial courts for civil and criminal matters that are typically authorized to hear any matters not exclusively designated for the lower courts of limited jurisdiction. In some states, they may even have concurrent jurisdiction with lower courts on some matters, such as misdemeanors. It's referred to as what we call district courts, circuit courts in certain states, or superior courts in like New York and places like that. But in North Carolina, we call this district court. In North Carolina, district and superior courts occupy this level. Of course, superior is a step above, but it's within a certain level, and some would even say that maybe the district court level may be down there in a limited jurisdiction, but based upon my knowledge, it's actually in this general jurisdiction because they hear so many different types of cases. So it's more general jurisdiction. District court has original trial jurisdiction over misdemeanors and civil cases with an amount in controversy below $25,000. Superior court has original trial jurisdiction over felonies and civil matters with amounts in controversy greater than $25,000, or $25,000 or greater. It has concurrent and appellate or trial de novo jurisdiction over misdemeanors. That's superior court. So what that means is in district court, if you have a misdemeanor trial as a defendant and you lose and you want to appeal, once again, district court in North Carolina is also not a court of record. So when they appeal to superior court for a trial de novo, and that's with only criminal cases. So they appeal to superior court for a trial de novo, jury trial. At that point, they have the trial. If they lose from there, then they go up to the next tier, which we'll talk about in a minute. Well, actually, which we'll talk about now, appellate courts. So appellate court, state appellate courts. A century ago, the state court system included only a single appellate court, the state Supreme Court. As the number of cases appealed increased and threatened to overwhelm the state courts of last resort, states created intermediate appellate courts of appeals. This is kind of to help spread the caseload. So these appeals courts can catch stuff before it gets up to the state Supreme Court. Okay, as the number of cases appealed increased and threatened to overwhelm the state courts of last resort, states created intermediate appellate courts of appeals. They're referred to as appeals courts, appellate divisions, and courts of appeal, or courts of appeals. They hear civil and criminal appeals from lower trial courts within their jurisdiction. Defendants who have been convicted and sentenced in a state trial court have the right to appeal one higher court to have the appeal heard by the court. This right to appeal ensures that the law was applied and interpreted correctly and that proper procedures were followed at every stage in the process. There is no right to appeal mentioned in the U.S. Constitution. This right comes from federal and state legislation and state constitutions. Appellate courts do not decide matters of fact or retry the case to determine guilt or liability, but they review the record of the trial to determine whether or not there were any errors that affected the fairness and constitutionality of the trial. That's what they do. So they're not hearing the case and trying it again or even hearing the facts. They're looking at specific things that happened to determine whether or not something happened that was unfair. Appellate courts have both mandatory and discretionary jurisdiction. Mandatory jurisdiction means that the court must hear all properly filed appeals. with intermediate appellate courts and Supreme Courts in states where there are no immediate appellate courts. So if there are no appellate courts below, then they're mandated to hear the cases. Like with Supreme Courts in the states, if they don't have appellate courts below them, then they almost, as a matter of right, have to hear everything, and they don't have discretion. Discretionary jurisdiction means that the court can decide which cases it wants to hear. State Supreme Courts, the last step. The court of last resort on the state level. 48 states have one court of last resort. 2 states, that's Oklahoma and Texas, have 2 courts of last resort, one for civil and the other for criminal. The number of justices on these state Supreme Courts varies from state to state, with 3 being the least and 9 being the most of all the jurisdictions. They usually hear cases on a discretionary basis in order to only focus on cases involving significant legal issues. The exception in those states with no intermediate appellate court, where it's not discretionary because they have no appellate court below them. They got to hear everything. Most states require that their Supreme Court hear all appeals in cases involving the death penalty. This is an extra safeguard to ensure that the trial was fair in a case with such a harsh punishment. In most states, the only option for a losing party in the state Supreme Court is to appeal directly to the United States Supreme Court, but only where there's a legal question that involves the U.S. Constitution or the federal law. You just heard about that when I talked about the federal side. If there's no federal question or constitutional question, there's no United States Supreme Court jurisdiction. They're not going to hear it. Okay, now let's talk about the court actors. First, you have the judge. The judge serves as an impartial referee responsible for enforcing court rules, instructing the jury on the law, ruling on the admissibility of evidence, determining the law, and also sentencing convicted defendants in certain situations. For the most part, some jurisdictions allow juries to sentence, to render not only issue a verdict but render a sentence in certain cases. but most jurisdictions, the judge, they're in charge of sentencing the defendant. Bench trials where a case is tried by a judge alone with no jury, and the judges rule on the law and evidence as well as determine guilt and liability. So that means in a bench trial, it's just the judge and jury. Judicial selection methods. You have appointment, and that's where the governor or, in the case of federal side, the president of the United States, or what they call the chief executive officer of whatever the jurisdiction is, either the governor or the president of the United States. They can appoint a judge. So it's the oldest method of selecting judges, where the chief executive officer of the jurisdiction, president or governor, selects a judge. Impeachment, and this is how judges can be removed. A formal process for removing judges where there are charges of impropriety tried by a legislative tribunal. The next method of selecting judges is by general election. The judge's name is on the ballot, and that's how it grows in North Carolina. So judges are usually appointed when there's a vacancy, and that vacancy has to be filled before the election cycle or the end of that term. So at that point, the governor can appoint and will appoint and put someone in that position to serve, and if that person wants to stay there, they're now going to have to file and put their name on the ballot to run as an incumbent. So that's how the election process goes. The most commonly used form of judicial selection, where the judges are selected in a popular balloted election. Sometimes in certain jurisdictions it's partisan, meaning it's based upon party lines. So the judge can run as a Democrat or Republican, or whatever their political party is. In states like North Carolina, it's nonpartisan. So you run off the partisan ticket. You run just as who you are, not as Boyce the Democrat, but as Boyce who wants to be judge, the lawyer who wants to be a judge. That's how you run. Now, that doesn't negate the fact that you probably are a Democrat or Republican, right? And it kind of can become quasi-partisan because people know what party you're affiliated with, so they still make their decision based on it. But you're just not on the ballot straight ticket as a representative of that party. Then you have the merit system, or what some people call the Missouri Plan. It's a form of judicial selection where a nonpartisan nominating committee selects a list of potential candidates based on qualifications. The governor makes a selection from that list, and the selected judge, once they're selected from that list, they have to stand or be a part of a retention election within a short time after being selected. So usually after a year or whatever term they're serving, they're on the ballot by themselves, and the public says whether or not we're going to keep them. So the retention election, that's what it is, where the selected judge runs uncontested, and the public votes on whether or not the judge should continue to serve or not. So at least you're not challenged by someone. It's automatic. Your name has to go on the ballot, and the people have to say thumbs up or thumbs down. Now, the prosecutor. These are, and of course, all these court actors, we're talking about them shortly now, kind of briefly going through them, but in future chapters, there's a chapter on each court actor where we really talk about them. The prosecutor, the attorney's tasked with bringing criminal charges against individuals who are accused of a crime and to represent the government's interests in court. On the federal side, the U.S. Department of Justice is headed by the United States Attorney General. The deputized or assistant attorneys who are delegated to prosecute cases under his or her administration are called U.S. attorneys. There are 93 United States attorneys appointed by the President of the United States for the various judicial districts, with more than 4,000 assistant or deputy U.S. attorneys working under them. State Attorney General is the state's chief legal officer representing the state in court when the state laws and policies are challenged, but plays a very limited role in criminal trials and does not supervise the activity of local prosecutors. Attorneys who prosecute criminal cases are found at the local level. The chief prosecutor or district attorney, as it's called in North Carolina, who in all but 5 states are elected, and his or her deputies or assistants charge and prosecute those accused of crimes at the local or county level. Guilford County, this is a nice tidbit. In Guilford County, here in Greensboro, North Carolina, Avery Crump currently serves as the first black female to hold the position of district attorney for Guilford County. She was elected in 2018. State and federal prosecutors' duty is to prosecute cases on behalf of the citizens, but also to do and seek justice by pursuing only those who have in fact committed crimes. They are there to pursue not just convictions. That's what they're supposed to be there. They're not supposed to be there just to get convictions and numbers, but they're there to pursue the just outcome. So someone could be accused, but if they're not the person that did it and their facts to show that, a prosecutor doesn't want to win well enough so much that they're willing to send someone innocent to prison. So they're about the people and and getting a just outcome of the case, even if it means they lost. State and federal prosecutors have a significant amount of unchecked discretionary power. We'll talk about that in the future, including deciding who will be charged, deciding what they will be charged with, what plea bargain to offer, presentation of evidence to prove guilt beyond a reasonable doubt, making recommendation regarding bail, recommending sentencing. Upon defendant's appeal, the prosecutor or agent of appears before the appellate court to argue that the conviction should not be overturned. So they have a lot of power in the system. We'll talk about how important they are. Then you have defense attorneys. These are attorneys hired or retained to represent their clients or defendants zealously without regard for the client's guilt or innocence, while acting within the rules of court and professional conduct. Gideon V. Wainwright, which we'll go over again, said lawyers in criminal courts are necessities, not luxuries. Indigent defendants charged with felonies are entitled to lawyers to assist them in their defense. This is from Gideon v. Wainwright. The case, the right was later expanded to any case where the defendant could be sentenced to active jail time. The right applies to all critical stages. This is the right to an attorney, appointed or retained. It applies to all critical stages of the trial process. There's also the right to hire an attorney or to have one appointed if you're indigent, but there's also the right to represent yourself pro se. That means not to have an attorney and to represent yourself. Not a great idea, but the law allows you to do it. It's actually your constitutional right to do it. It's one of your options. When a defendant is allowed to represent themselves after the court determines that they are competent to do so, that is pro se or self-representation. Public defenders, they're salaried government employees that are hired by the state to represent the interest represent the interest of indigent or poor defendants that cannot afford to hire their own attorneys. And of course, we have a whole chapter on defense attorneys, so we'll, all this stuff, so we'll dig into it. So I'm just briefly brushing over it now. Court-appointed or contracted private attorneys. Private attorneys appointed by the court or contracted by the state to represent indigent defendants at a set hourly rate or fixed sum. Roles of defense counsel: ensure the defendant's rights are not violated, make sure the defendant has the information necessary to make informed decisions about pleas and trial, to investigate and prepare a defense, and if necessary, argue for the lowest possible sentence or the best possible plea bargain. Defense attorneys are different from prosecutors in the fact that we don't cover the interest of everyone. As a matter of fact, we could care less about society as a whole. We represent that one client that's in front of us, and that's whose interest we're looking out for. Now, we may use arguments about everyone's rights in the Fourth Amendment and how it applies, because those constitutional rights apply to everybody. But we're mentioning that in the context of representing that one person. So we don't have an ethical obligation to seek the truth. We have an ethical obligation to zealously represent that one person. So that's the difference. Then we move to another court actor, jurors. The people selected from a cross-section of the jurisdiction that are tasked with deciding whether those charged with crimes are guilty, and in some jurisdictions, what the sentence should be if the defendant is convicted. Jurors are rarely used because most cases end in guilty pleas. Like 90+% of cases in the criminal court system are played out. So when you see a trial that is literally like between 1 and 10% of all the stuff that came through. Everything else was either dismissed because, pre-trial, or it was played out, some type of deal was made. The jury pool, or what they call veneer, the method of selecting names of citizens that will be called to possibly serve as jurors. Jurisdictions can use voter registration lists, driver's license lists, and other lists that are likely to include as many people as possible. That's the one reason why you want to register to vote wherever you live, is because not only are you tasked, or should you go out there and vote and cast a ballot in elections, but it also gives you the right to serve as a jury. In most general elections, some people say my vote don't count. But one place where your vote does count is when it's you in a room with 11 other people having to make a decision that has to be unanimous. That means your vote does count. Whether you say guilty or not guilty, that it counts, because if everyone else doesn't say it the same, or you're different than everyone else, or different than any one other person, then that's not a verdict. You can't walk out of that room with a verdict unless everyone says it. So that means everyone's vote is important. So that's definitely the ultimate means of being involved in the political process, and that's serving as a jury. So that's why you want to register to vote. Jury panel, individuals selected from the jury pool for a particular case. Voir dire, which is French for to see and to speak. That's the jury selection process, voir dire, whereby the jury panel is asked a series of questions by lawyers and the judge in order to determine whether the potential jurors are unbiased and can decide the case fairly and impartially. Each side has a different set of, the same set of challenges. The challenges is when you ask that a juror be removed from the panel. First is challenges for cause. You have an unlimited. Both sides have an unlimited amount of challenges for cause. What that means is there's unlimited opportunities to strike a potential juror who, based upon the answers to that question, they essentially let you know that they cannot be fair and impartial. So that's the number one rule. Your jurors have to be fair and impartial. If they can't do that, or they can't be fair, they can't listen to the case, or they have some type of moral or ethical issue, then of course you have to challenge them for cause and get them off the jury. Then you have preemptory challenges, limited opportunities to strike a potential juror without giving any reason at all. Now those are limited. In North Carolina, you get 6 per side. The DA gets 6, the defendant gets 6. And when they're making decisions, they can be based upon anything. It's not supposed to be based upon race, especially if you're the prosecutor. But if you're the defendant, we don't care about everyone else. So if my client's black, I probably want black folks on that jury. So, I admit I've made some preemptory challenges just because I need some more color on this juror, because I need these people to look. I need someone on the jury to look like my client in certain situations. So, other actors, you have the bailiff, and the bailiff is law enforcement officer tasked with maintaining order in the courtroom and transporting incarcerated defendants to and from court proceedings. You have the court administrator, who works behind the scenes. They're usually hired by the chief judge, and they're tasked with facilitating and scheduling of court cases and the smooth flow of cases. They maintain court records, schedule hearings, and manage court personnel. And they, like I said before, they tend to work behind the scenes. Then you have the court reporter, or stenographer, as they call them sometimes, one who is present in the court and tasked with recording all court proceedings and to produce a verbatim transcript or recording. That means everything that was said of the proceedings. This is only present in courts of record. So in North Carolina, in magistrates courts and district court, depending on what type of district court it is, they're not courts of record. So there's some courts of record where there's not a court reporter, but everything's recorded because everything's mic'd, and there's they keep a recorded record of everything that was said. But in Superior Court, those are courts of record where there is a court reporter or stenographer there that's not only listening to everything, but keeping it tight fast. They're keeping a word for word record of what happened. Let's see. Then you have the clerk of court. This is the custodian of court records, one who is tasked, and they're also in court, one who is tasked with maintaining the records of all cases, including court files and official court rulings, preparing the jury pool, issuing summonses for jury duty, and issuing subpoenas for witnesses and to testify at trial. The current acting elected chief clerk of Superior Court in Guilford County, North Carolina, is Lisa Johnson Tompkins. She is an Aggie. So she is an Aggie, and she is also the first black female to serve as the clerk of Superior Court in Guilford County. So clerk of Superior Court. Then you have other parties involved, other court actors. You have expert witnesses. These are witnesses called upon to introduce scientific and other complicated forms of evidence or to prove specialized knowledge to the jury that will assist the jury in reaching a verdict. Then you also have lay witnesses. These are witnesses who possess no specialized knowledge that are called to testify about what they know of a matter at hand or what they perceive. So tell us what you saw, as opposed to what your opinion is based upon this very technical situation. They're not allowed to offer opinions. They're only allowed to talk about what they perceived, and that's it. They're telling us what happened. So only what they experienced with their 5 senses that is relevant to the case at hand. Now we'll do an overview of the criminal process. You have the pretrial proceedings, where, of course, you have the person that's arrested and they're served and they're booked. Then they go for an initial appearance where sometimes the bond is set or the conditions of pretrial release is set. Then they're arraigned, which is another first appearance. And this doesn't happen in all jurisdictions. It's a preliminary hearing where defendant is formally asked how they wish to plead in the matter. So you have different types of pleas. You have standing mute, meaning you don't wish to be heard at all. You have not guilty, saying I didn't do it. You have guilty, meaning you admit guilt and you're taking the punishment. You have offered guilty plea, which is essentially where you enter a guilty plea, but you deny committing the crime. In other words, I didn't do it, but I'm going to say I'm guilty because what the prosecutor is offering me is better than risking going to trial and possibly losing, even though I didn't do it. That's the one thing about trials. Just because you didn't do it does not mean you're going to go to trial and win. There are a lot of people that are wrongfully convicted, and it happens way too much. To the point where most trials, I hate to say it, most trials come out with guilty verdicts, and that's just is what it is. So do you want to risk that, or do you want to take this deal from the DA that allows you to earn a dismissal after you do community service? So that's why so offer guilty plea is a guilty plea where you're saying, I admit guilt. I'm saying I'm guilty, but I didn't do anything wrong. I'm only saying it because it's a good offer and I'm taking the offer, and it's in my best interest. So that's the offered guilty plea. Then you have the no contest or nolo contendere. That's when the defendant does not accept any criminal responsibility, but accepts whatever punishment the court would impose on a guilty defendant. In other words, I'm not admitting guilt, but punish me. It's used by clients who want to avoid civil liability because what you'll learn is, and I think we talked about this in prior chapters, is that sometimes what you're accused of doing criminally can also get you sued. So remember, there's a very high burden of proof in criminal cases, right? So it's harder to prove criminal cases than it is civil cases. So if in the criminal case you admit guilt, that admission of guilt can now be used in the civil case, which has a lower burden of proof, to show that you're liable, right? So a lot of times people use a no contest plea as a form to say I'm not admitting guilt, but whatever the court does is what the court does. You can punish me, but I didn't do it. But I'm not saying I did it. And then there's also what we call, and it's kind of akin to what we in North Carolina we call it pleading not guilty, but not resisting a verdict of guilt. It allows the judge to find a defendant guilty as if they had a trial and a verdict. It's a good look for the judge politically. So, but it's the same thing as pretty much no contest. It's saying I ain't do it, but I'm pleading not guilty, but you can find me guilty. So by finding the person guilty, that means that essentially it skips the trial process and the court finds the person guilty. Then you have preliminary hearings and the indictment process. Then after that, you have pretrial motions, motion for discovery. Sometimes you have motions to suppress. That's where those are filed, where they say, hey, my client's rights were violated or the evidence was obtained illegally, so we want to suppress the evidence. Then after that, you have jury selection, and then you have the trial. In the trial, you have the initial arraignment where they ask you, how's your client plead, guilty or not guilty? Once you say not guilty and you're arraigned and you say not guilty, at that point, jeopardy attaches. That means you are now in the frying pan. Both you and the prosecutor are in the frying pan. So however it comes out, you're in it now. You're already burnt. You're in the fire. You're cooking. So you have opening statements. You have the prosecutor's case in chief where they put on evidence and witnesses. And of course, the opposing party has the right to cross-examine witnesses against them. So they cross-examine witnesses. That's where they enter their, of course, in their case in chief, that's where they enter evidence. No physical evidence gets in without being testified to, regardless of what it is, and it's relevant to the case. So that means to most testimony, pretty much all evidence is testimony and based on testimony. So even if there's a physical evidence like the gun used in a murder, it doesn't even come in unless someone can testify to what it is and why it's connected to, why it's relevant to the case, and why the conclusion is drawn that is the murder weapon. So evidence just doesn't walk in; it has to be testified to. After the prosecutor's case in chief, the defense gets the opportunity to go if they choose. Remember, they don't have a burden of proving anything, so the defendant actually doesn't have to put on any evidence. They can stop right there and say and tell the jury that, hey, this case is terrible. Acquit me. But if they do decide to put on a case in chief or put on evidence, the same thing goes. They can directly examine or question their witnesses, and all the witnesses they put forth are subject to being cross-examined by the other side. Then from there, you may have post-case motions or then you have closing arguments, and that's like a summation of everything that happened. It's argumentative as opposed to opening statements, being just a you're kind of giving a what do you call it? Trying to think a forecast of what your side is going to say, and what evidence you're going to present, and what witnesses you're going to present. But it's not argumentative in the opening statement, because that's why they don't call it opening argument. They call it opening statement. Is because there's nothing to argue yet. No evidence has been put forth. It's the beginning of a trial, so we don't even know what we're going to argue. So, but at the end, after all evidence has been put forth, that is now it's not called a closing statement. It's called a closing argument, because now you are arguing. You are saying, you're talking about their witnesses they put on and why they're not believable, why yours said this and that, and why they should be trusted. So that is a closing argument. Then after that, you have the jury instructions hearing, where you decide what pattern jury instructions or what the law is going to be applied, and what the jury is going to take back to there with them as the law that they're going to use in deciding the case. And then you also have jury instructions. Once you decide on that, then the jury goes to deliberate, and they come out and they give a verdict, and then they're sentencing. So that's how it goes. Of course, at sentencing, if a person is found not guilty, they're set free. They go home. Double jeopardy has attached at the final arraignment right there before the trial started, so they can't be tried for it again. The sentence is determined. If they are convicted, a sentence is determined based upon the classification of the convicted crime and the criminal history of the defendant. We'll talk more about that when we talk about sentencing later on in later chapters. Then the next level is appeals. If the defendant loses in a criminal case, they can appeal. If a prosecutor loses in the case, remember there's double jeopardy, so they can't appeal. They got one chance to win the trial. If they lose, they can't file for appeal. The only time prosecutors can appeal is if in the pretrial phase there's certain motions that are filed, like motions to suppress, and they might lose one of those motions where certain evidence gets excluded because the defense has argued against it and said that it's violative of their client's rights. At that point, they can appeal, but they have to appeal right there. So the court has to appeal. The court of appeals and the higher courts get to determine whether or not the court was correct in granting or not granting a certain motion, pretrial motion. But that's the only time that prosecutors can appeal. At the end of a trial, if they lose, they lose. The person walks, and that's it. Direct appeal, it challenges the validity and fairness of the defendant's conviction. An indirect appeal, which would be a habeas corpus, does not directly challenge the validity or fairness of the defendant's conviction or the trial, but it challenges the authority of the state to incarcerate the defendant. And that's a habeas corpus. So that is chapter 4. So once again, as I said before, it's incumbent upon you, it's your obligation to read the book and study these materials. You can go to the website to do questions and prepare. As I gave you the website before, I'll give it to you again. You're going to hear this from me a lot. You can go to www.sage.pub.com. That's www.sagepub.com. And you can actually search and put the book name in, and they'll send you. You can click on and go to the book's website. Or you can use Sage Edge. So for the book, it would be www.edge.sagepub.com/HEMMENS, the number 4 and the letter lowercase e. So that's Hemmings 4E. That's Hemmings 4E, essentially this guy. Craig Hemmings. So it's the main author or editor of this book. So yeah, you click on that and you can go. I would say use the resources. You can do review questions and little quizzes they have. As a matter of fact, you can, after you do them, you can print off the answers and figure out what you got wrong and what you got right. And you might very well see those questions again. And you actually will see a lot of them again, because I've told you that's where I get a lot of my test questions from. A lot of them, not all of them. Some of them I make up, but a good bulk of them come from there. So that's all for chapter 4. You guys be good.